recording. Okay. So hello everyone. Welcome to this final session of ACIL this year, and it has been a wonderful experience. It is a great privilege and honor for me to introduce a galaxy of panelists. So we are really happy to have some, very famous people who hardly need any introduction, but just for the sake of completeness, let me take some time to introduce them. So I will go in the order in which I have their bios. So first, it's a great honor to have Professor Pushpak Bhattacharyya, who is a professor of computer science and engineering department of IIT Bombay. So he was formerly the director of IIT Patna, 2015 to 20, and president of Association of Computational Linguistics in 2016. He's a fellow of National Academy of Engineering 2015 and Abdul Kalam National Fellow 2020. So his area of research is natural language processing and machine learning, though he has expertise in several other areas. He has a lot of accolades, so I can write a book on this. So basically, it's a great honor to have him. So to just mention some of his accolades. So for sustained contribution to technology, Professor Bhattacharya received H.H. Mathur Research Excellence Award of IIT Bombay 2021, Manthan Award of the Ministry of IT 2009, P.K. Patwardhan Award of IIT Bombay 2008, and VNMM Award of IIT Roorkee 2014. So his research has gained national and international visibility. His work on computational sarcasm with his students featured in the Times London edition. The deep learning based sarcasm research also featured in the MIT Tech Review and ACM Technology News. So welcome, Professor Bhattacharya. And to add to that, he was the consortium head of the consortium, under which FIRE was held. So it was a CLIA consortium. So it's really a great honor and privilege to have you as one of our panelists. So next,
thank you.
Yeah. So next we have Professor Pawan Goyal, who is an associate professor at the Department of Computer Science and Engineering, IIT Kharagpur. So prior to joining IIT Kharagpur, he received his BTech degree in electrical engineering from IIT Kanpur and his PhD degree from University of Ulster, UK in 2011. So he was then a postdoctoral fellow at INRIA, Paris. His research interests include natural language understanding, information retrieval, and Sanskrit computational linguistics. He has published over 100 research papers. He was the recipient of Google India AI ML Research Awards and INA Young Engineers Award. So welcome, Professor Goyal, and it's a great honor to have you as one of the panelists.
Thank you.
So next, it's a great pleasure to have Professor Uday Shankar, who is an associate professor at the Rajiv Gandhi School of Intellectual Property Law at IIT Kharagpur. He has served as a guest professor under Magdalene Koch Fellowship awarded by the Faculty of Law, University of Hamburg, the year 2016, and recipient of the prestigious fellowship from the Max Planck Institute of Comparative Public Law and International Law, Heidelberg, in the year 2008. He has participated in law teaching and legal research program at Cardiff University, UK. He is a member of Indian Association of Constitutional Law. He also has a lot of accolades. So he's also a member of the International Society of Public Law. He teaches and researches in the area of public law. He has completed his graduation, post-graduation, and doctoral degree in the law from Faculty of Law, University of Delhi. So it's a great pleasure to have you, Professor Shankar.
Thank you, Professor Kripa. Thank you.
Next, it is again a great honor to have Professor Prabuddha Ganguly, who is CEO of his consulting firm Vision IPR, offering services in management of IPR and knowledge management. He spent over 20 years with the industry in diverse managerial roles spanning research, R&D management, strategic management of IPR, factory management, and so on. He served as honorary scientific consultant for innovation and IPR matters to the Office of Principal Scientific Advisor, Government of India from 2005 to 2017. In addition to his global consulting assignments, including with the World Intellectual Property Organization, and a consultant to various governments around the globe to design their national innovation and IPR policies, he is visiting professor advisor in several universities and IITs. He has lots of publications in technical fields, including invited chapters in several edited international volumes in IPR. So it is also a great pleasure and honor to have you, Professor Ganguly, as one of our panelists.
Thank you.
And it is also a great honor to have Dr. G.R. Raghavender, who is a Joint Secretary, Ministry of Law and Justice, Government of India. Previously, he was a Joint Secretary in Department of Industrial Policy and Promotion, Minister of Commerce and Industry, Government of India, New Delhi, from August 2015 to January 2017. He also held additional charge of Director General, National Productivity Council, NPC, from November 2015 to May 2016. He is interested in intellectual property rights, especially copyright and related rights. He also worked as a registrar of copyrights of the Indian Copyright Office for about 6.5 years, and played a key role in the introduction of amendments to the Copyright Act in 2012 and the introduction of Copyright Tools 2013. He attended many WIPO SSR meetings, regional comprehensive economic partnership, free trade negotiation, and other FTA negotiations. So he's also a giant figure, and it's a great honor to have you, sir.
Thank you.
And this panel discussion will be basically coordinated by Professor Partha Pratim Chakrabarti, who is currently a professor of the Computer Science and Engineering Department at IIT Kharagpur, and with a joint appointment in the Center of Excellence in Artificial Intelligence. From July 2013 till July 1, 2019, he was a director of IIT Kharagpur. So he also has a lot of accolades. He received the President of India Gold Medal in 1985, the INSA Young Scientist Award 1991. I can basically write a book on this also. And he received Shanti Swarup Bhatnagar Prize in 2000, INA Vishweshwaraya Chair Professorship 2007-9, JC Bose Fellowship 2019, and many other awards. He has been elected a Fellow of the Indian National Science Academy, New Delhi, and the Indian Academy of Science, Bangalore, Indian National Academy of Engineering, and the West Bengal Academy of Science and Technology. He received a DSc honoris causa from Kalyani University in 2019 for his contributions to science and technology. So thank you very much, sir. And he is one of our organizers and one of the chief motivators of this symposium. And he has been instrumental with his very insightful inputs and guidance, which has been a key factor in organizing SAIL for the first time. So I will humbly request Professor PPC to take over.
Thank you, Kripa. Welcome, everybody. And I'm really grateful to all of you for joining. Kripa has made us look like Oscar awardees, you know, the way Oscar awards are announced. Almost that way he has tried to introduce us all, which is a good thing. Thank you, Kripa. These 5 days have been very fascinating. We have had world-renowned experts discussing topics on AI and law. And this is a very unique symposium being held for everybody to participate, especially organized by a lot of young scientists, researchers across the board in India, from India, and other countries, including Australia, UK, US, France. And I'm really grateful to all of you for organizing this. As we come to the end of the day, the end question always is that what do we do for India? And when you come to India, you have many questions raised. What laws need to change? How do we clear the backlog? What is machine learning applicable for India? For this huge translational part that is important, how do we handle it for India? And then all the typical philosophical questions and the most practical questions that are for India. We have a very eminent panel, so I don't want to engage upon all the topics that are to be discussed. I will first request all the panelists to speak for 5 to 6 minutes, and then we will open it up for questions. So may I request Professor Prabuddha Ganguly to kindly start with
Thank
his
you very
initial
much,
remarks.
Professor Chakrabarti. What I'd like to do is to really get on to a bit of the philosophical aspect of this particular subject, where we look into the interface of artificial intelligence and law. Where do these meet and why do they have to meet? So I'll try to look at that in the coming 5 minutes. And therefore, I would like to start with the very first question as to why do we need laws? And obviously, laws are required because we live in a society. And therefore, the composition of a society and the dynamics of a society plays a very important role as to why we need laws and what sort of laws do we need and how do we really administer these laws in society. And therefore, when you come to this particular bit, we know that societies nucleate and grow. How do they grow? As a result of a range of interactive processes between humans who are products of long evolutionary process. We are all products of long evolutionary processes. And the social dynamics between humans and further between humans and other beings such as animals, for example, is mediated by communication. So we have communication as a means of growing between us. And behavior in all its variants is a consequence of these interactions. Now, what does law do? Law provides a codified system to examine whether certain human behavior is within the ambit of set norms or it deviates from the set norms and helps to arrive at possible consequences in the form of reliefs or liabilities. That's what law does. It provides some sort of a platform or a framework to operate. So society operates on that sort of a framework. This brings me to the first issue to tackle with regard to artificial intelligence systems on their own, and then artificial intelligence systems associated with humans in all its variants. So if you look at it, that where is artificial intelligence today? So to start off, the most advanced autonomous AI systems of today can think, can analyze, can articulate, can communicate, and almost act as humans. That's the stage at which we are at this point in time. We may term all these systems as AI sapiens, as if like Homo sapiens, they become AI sapiens. And these AI sapiens are multi-agent systems which have the power of artificial intelligence endowed with best machine learning modes, complex neural networks, and fuzzy logic. Now, therefore, these smart social AI systems, in time will have graduated beyond mere conventional or conversational agents with abilities to see, hear, and respond to transformed, independent, and lifelike, emotive, rapid learners and autonomous creators and performers with possibly in future with humane traits. These generation of AI systems holds a promise of leapfrogging from humanoids to AI sapiens, unshackling themselves from most human limitations. Therefore, let us look at what's going to be the cultural society of tomorrow. The cultural society of tomorrow will be a hybrid society of various types of beings with all permutation combinations of existing humans that are Homo sapiens and animals as they exist, then created AI sapiens. So we are going to create a whole bunch of new beings called AI sapiens. Then we have AI assisted Homo sapiens because we are going to use a lot of these AI means to get assisted. So there'll be assisted, AI assisted Homo sapiens, AI assisted other beings. And then we are going to have AI enhanced, Homo sapiens and AI enhanced other beings. And there will be variants of this type. So therefore, the society of tomorrow is going to be very different from the society of today. And therefore, when we now crystal ball into the laws in a very, if we look at in a, prescriptive, descriptive, and predictive modes of governance and laws, this becomes very complex in this particular society. So the first question in law that's going to be asked out there, and we'll have to find answers to it, is whether AI-based systems, these AI sapiens, as I call, should they be granted personhood? Should they be called as persons or should they be called as machines? And therefore, it's going to be very fundamental. And if so, what would be the contours of this personhood? And if not granted personhood, then what would be the status of such AI-based systems in the eyes of law? Because we need to answer this particular question as we go along. The second part, which is going to be very important, is that even if these AI sapiens are not granted personhood, but are utilized in diverse applications, such as in agriculture, healthcare, financial services, administration, judiciary, etc., in the within course human or Homo sapien society, then the question is, what would be the legal, regulatory, and ethical frameworks for their use? And we'll have to consider all these aspects of autonomics and orchestration while drafting the laws and regulatory frameworks. The third part, which is going to be very important, is that we are going to use a lot of big data for very large set of people, situations, experiences, and therefore ownership of big data is going to be a big issue on of anonymized personal data are of paramount importance. Laws governing data safety, privacy, confidentiality, and anonymity, data integrity, liability, and algorithmic accountability are some of the features that will have to be tightly built into our laws. And therefore, coming towards the end of this, the new era hybrid society will demand a completely and a total rethinking of the modes of societal governance and laws, challenging the fundamentals of jurisprudence related to personhood, responsibilities, contracts, liabilities, creativity, intellectual property rights. Enforcement is going to be a big issue out there. E-commerce in all its dimensionalities, job creations and job substitution and ethics are going to play a very important role. So all the laws related to these, and therefore in India, what we'll have to do is we'll have to comprehensively review even the Constitution of India to start with, because all our laws finally go and focus onto the Constitution. And therefore we'll have to look at the Constitution of India to explore the fundamental changes that will be needed to meet the future of such a complex hybrid society that we are about to create and leave for generations to inherit. And therefore, in conclusion, what I'd like to say in my opening remarks is that this has to be comprehensive, it's got to be holistic, and we'll have to look at these so that all these laws are going to get intertwined. And in this particular process of intertwining, we'll have to put in a large amount of transdisciplinary measures to look at it. And that's going to be the challenge in India. Thank you.
Thank you very much, Professor Ganguly. You have raised, as we thought, the most fundamental issue and have have actually taken it to the point that we really need to have a relook at the Constitution if required. And we will come back to your points. Already a question has been put in the question box regarding what you said. You may have a look at that. The others may kindly put their questions in the Q&A box. May I now move to the AI expert, Pushpak Bhattacharya. And Pushpak, my request to you is to please elaborate the scope for AI, where it is today, how is it going to come in the future, and what are the hopes and challenges that it produces for us vis-a-vis the law part. Pushpak, can you hear me?
Yes, I can hear you.
Yeah, thank you. Yeah,
Chakrabarti.
yeah.
So I hope I'm audible.
Yes, yes.
Okay. So I wanted to share my screen a bit. Is that possible? Yeah.
Sure, sure, sure.
Yeah. Yeah. Can you see my screen?
Yes, yes, I can see.
We can
Yeah.
see.
Yeah. Okay. So, Professor Chakrabarti, thank you. Thank you for inviting me, and thank you, Kripa, for this very generous introduction. So, this panel and the whole event is, of course, a very timely event, I would say. So, Professor Chakrabarti has asked a large perspective question about the nature of AI, future of AI, as it applies to law. So what I have decided is that the time that is given to me, the 5 to 7 minutes, I thought I will devote to this theme of pendency of court cases and how technology can help in this matter. That's a very specific and moot problem of current times. And we can see the importance of AI in general, taking this as a particular case study. So this is a well-known adage, justice delayed is justice denied. But we see and we firmly believe and think that technology can come to help here. So this particular diagram is of help, I believe. So the technology intervention for law comes in these 4 shapes. One is translation. So a long time back, I was told by Mr. F.C. Kohli, who is famously known as the father of software engineering in the country, that can natural language processing researchers do something to reduce the delay that is incurred when court cases move from lower court to higher courts, because that entails translation of these court cases into Hindi and English. And there have been instances where this whole translation process has taken 3 to 5 years, and thereby justice was very severely delayed. The whole process got delayed. So translation is one particular case in point, and we have made considerable progress in this. Information extraction, and it is known that in judicial matters, the personnel involved in law have to read an enormous amount of text, okay, and collate an enormous amount of information, refer to large number of laws, clauses, sub-clauses, and this becomes a very complex task. This is again a situation where machine steps in and does information extraction, mainly to give entity relationship information from this text. So this is information extraction. And one of the problems here is name normalization, on which also we have done some work. Then case similarity is very important in the judicial scenario. New cases have to be pitched against old cases, similarities and dissimilarities identified, and the rules and laws that were applicable then are invoked once again. And if there are exceptions, those are identified again. So here again, AI can help a lot and is helping actually through the techniques of document classification and clustering, and also paraphrasing. Now, application of laws and clauses to a particular case is actually an exercise in natural language inferencing, which is based on principles of logic, which is about 2000 years old, and predicate calculus, propositional calculus, modal logic, deontic logic, etc., and manifestations of those systems. So these are the different cases, situations where AI can help law and is also helping law immensely. Now, the pending cases in India have crossed 4.4 crores, up by 19% since last year. This is the data given on April 2021. And if we do a bit of Google search and go to Supreme Court website, then there are pending matters as on 1st May, numbering about 70,000. And of course, 19% matters are incomplete because not all the relevant information is in, but still there are huge amount of backlog. Now it may interest the audience to note something amusing. I remember once our Honorable Minister of Law, Shri Shankar Prasad, in an AI meeting in ministry, had mentioned that 80% of the cases are on traffic violation, okay, which is a very interesting fact. And I believe Professor Chakrabarti also was present in that particular meeting. And it was very interesting and amusing for many of us. So now, if you see various data on Google for civil, criminal, and total number of cases, the pendency of cases which are waiting for 0 to 1 year is about 27%. Above 30 years, also there are a few cases under civil, for example, 0.37%. And similarly, criminal and total. So this is actually a real problem, and it needs attention. The Honorable Minister has mentioned this many times to AI researchers, and technology does and can indeed help. So we go back to this particular diagram, and one of the important tasks is name normalization. So here is an example. The same person may be referred as lawyer, counsel, learned counsel, advocate, as well as by his or her proper name. So these names have to be co-referred and made to correspond to one single entity in real life. Okay, so there has been some work in that front by us in our group. And finally, I will end with another technology which is based on logic. This is text entailment. And there is a definite case for the application of text entailment. Text entailment does a three-way classification applying machine learning technology. Two pieces of text can be in entailment relation, like every employee must file tax return, entails an employee must file tax return. There can be contradiction. Few parrots flew over the country or fence. All parrots flew over the fence. That would be a contradiction. This movie may break all records. This movie breaks all the records, may and breaks. This is a situation of neutral relationship between two pieces of text. Now, what is the application of this? I have taken a particular case, Angana and ANR versus State of Rajasthan. And here is a court judgment. So if you go through the case, there are sentence after sentence, very long ones, making reference to many entities and their relationships, the situations they were in. And finally, there is this last part of the text, which says, taking into consideration over all view of the matter and in particular offense alleged and so on, it goes on. The High Court could have suspended the sentence and granted bail to the appellants. Therefore, the court would be justified under Article 136 of the Constitution in interfering with the discretion exercised by the High Court. So, final statement is always in this form, therefore, and there is a reference to a particular article or a particular clause of a law, etc., etc. And this is a clear case of an entailed text coming from the text that precedes it, not only in the same document, it can be in many other documents. And this entailment is distilled, okay, from lot of text. And there is a solid case for application of text entailment or natural language inference in law coming from AI. And these technologies now exist in the age of deep learning. The child is getting a pedicure is the premise, the kid is getting a manicure hypothesis, and two parts of the deep learning system can interact to solve this problem. So summary of whatever I said is that AI has huge scope in law, but of particular interest personally for me also is the intervention of technology to reduce pendency through the techniques of translation, information extraction, case similarity, and cause application, namely text entailment. Thank you very much.
Thank you. Thank you very much, Pushpak. This was a very eye-opening remark, mainly because of the pendency. And I will come back to you on two very important things that you have mentioned. One is pendency or delays, which can be enhanced and the speed up can be done, and assistance can be provided to the legal community through AI. The other question which I will come to you in the next round, so I wanted to just put you up on this, is are we ready for machine readable legislation? So that means if we are going to go for such kinds of entailments and analysis using AI and machine learning, especially in the language context, how is our readiness for machine readable legislation? But before we come to that point, I will also request you to have a look at the QA box where some questions will come.
Right.
I will now move on to Professor Uday Shankar, who is a legal expert. Constitutional law is his forte, environment law is his forte, but I think he will again come back to this pendency issue, which I will request him to look into. And how can we handle it procedurally? How can we handle it by a legal mechanism? And several other points. And I leave it to him to give his initial remarks in his own way. Uday, please.
Yeah, thank you, sir, for very aptly highlighting the concern which has been plaguing this sector. And I will also make this point very clear, as Professor Ganguly has referred to the very text of the Constitution and what Constitution is saying or indicating in this regard. So when I read the Constitution, one design is very clear, that the makers of the Constitution never thought of a huge pendency of cases in the code of law. And why I am building this premise, that the Constitution provides for the appointment of additional judges and ad hoc judges, so that this pendency should not be a matter. And I would say, if you expand this philosophy, it should be for every layer of the courts. And when we go by the statistics, as it was presented by Professor Pushpak, that we have such a huge pendency, and that pendency is there at every layer of the courts, right from the Supreme Court and down up to the lower courts. And the statistics says that we have a judge population ratio of 14 judges per million. And in order to address the issue of pendency, perhaps we may need 50 judges per million. Shall we wait till the time when we get such appointments? Shall we wait till the time we train our people to resolve the dispute, get appointed as a judges? Or we need to act immediately in order to enhance the confidence in the legal system? And for that, AI appears to be a very formidable tool. And I would say that at least in 3 different baskets, 3 different areas related to judicial process, AI can be effectively implemented without much delay. And how I would classify those areas, I would say that one area is the procedural aspect, that right from the day when the case comes before the court and when the judge takes the evidence and applies law in order to examine the admissibility of the evidence for determining the disputed fact. Now, this very process of filing the matter and the matter arriving at the desk of the judge for appreciation of evidence, this itself consumes a lot of time. Now, this process is procedural, and to large extent it is a mechanical process, and it can be effectively addressed by employing technology. For example, notice to the parties, summoning, hard copies, whether it is in the right format or not, whether documents are admissible or not. For all these, there are rules which are there in every high courts and which are also applicable for the trial courts. Now, those rules clearly spell out that what are the do's and don'ts, and that can be effectively implemented with the help of technology. And if you look at the time consumed, in engaging this process, then it somewhere affects the expeditious disposal of the matter. And the same thing also applies when the matter goes for the appeal, that how the certified copy has been reached, whether certified copy is been properly produced before the appellate court or not. Now, I know very well that in this regard there are changes which have already been done, and the high courts are accepting the e-form of the order, getting it from the lower court. So changes are being done, but then there is a possibility of bringing this change on a war footing basis so that the pendency can be reduced to a large extent, because I very firmly believe that the judicial system till date has not been utilized to the best of its ability. The way we see the law and order issues in this country, had the judicial system performing to the best of its ability, so much of law and order situations would not have been there. People would have trusted the judiciary and approached the enforcement agencies, the code of law, for getting the redressal. Now, other segment where I see AI playing a very significant role, that there are certain laws which largely determines on the amount of compensation to be paid. I'll give an example of Motor Vehicles Act or Negotiable Instruments Act, and these acts are one of the main reasons for the pendencies, because good number of cases, let's say for example under NI Act, is pending. Now, these kind of cases where once the guilt is established, the quantum aspect of it can very well be determined with the help of technology, because these acts, they give the formula to arrive at the compensation. So even if we think that, okay, legal acumen is needed to decide that whether there is wrong done or not, then let that aspect be dealt by the judges. But once that is done, what shall be the quantum of compensation to be paid to the agreed party? Let it be done by AI. And that is all based on the scheme which is given in the law. And third one, I would say, where much of the time of the judges get consumed in administrative works. For example, high court judges, they look into the resource allocation affair, and accordingly they devise a way that how the judges are to be handling the matters at the trial court level. Now, with the help of AI, I believe it is possible that these exercises can be undertaken by the technology-driven system. So man hours of the High Court judges can be saved in this regard, which is purely an administrative function. Let's say, for example, in a particular district, there are a good number of family matters which are pending, and we need to expand the family courts. We need to have good number of family courts. Now, obviously, I have been told that this exercise is being undertaken by the High Court judges on administrative side. They regularly do the review of this say pendency, and then accordingly they take a call on it. Now, looking at the volume of work which is already there on the judicial side for these judges, why not to bring in AI so that this can be effectively discharged? It is all about allocation resources, which if AI can very effectively undertake. And I truly believe, and I want to stress upon it, that before concluding, that if we experiment this, and already the experiment has started by when we look at the recent announcement made by Justice Chandrachud, where he has already given a sort of go ahead for experimenting on use of technology for reducing dependency. That if we use this, if you use technology, it will not only enhance the confidence of the common man, but it will also make the access to justice reachable to the doorstep of the one for whom the legal system matters the most. And that's why we need to engage with the technology. As a law student, I truly believe that before time runs out, we must welcome this step. And the analogy I would draw is with the banking system, that the way the banking system has been reformed with the help of technology, same kind of reform is being needed in judicial process, in the legal system, so that access to justice becomes a reality and does not become only a matter of rhetoric. So with this, I conclude, and if there are questions, I'll get back on this. Thank you, sir, for giving me this
Thanks
platform.
a lot, Uday. Thanks a lot. I think you raised certain important points which talk about what can be done immediately. First, you talked about filing and admissibility, which can be done by automated checking, like you do tax submissions, like you do income tax submissions. And there you may have to add what Pushpak talked about is logical language analysis and entailment. The second thing that you talked about is quantum of punishment, where it is very clear. That means there can be certain aspects where we can get digital legislation in place. And I will ask Pushpak to talk on it in the next round. And if there are those places where we can identify immediately where this is possible, then I think the quantum of whatever is to be delivered can be done. But I will request later on both Prabuddha, Ganguly and Pushpak to talk about the safeguards against wrong decisions. So how are we, so I will request you also to think later on in the second round about safeguards against wrong decisions. The third thing you talked about, and I have been working on this for quite some time, is I analyzed cause lists and orders, and I figured out that this whole administration issue is the resources there are two kinds. One is scheduling, one is allocation. So the allocation and scheduling are very well solved problems in computer science, and they have not been used well in India. And I believe that that is possible. So very, very well articulated points by all the three. I will also request you to think, Uday, that will this not increase the digital divide? If we are to, while it has got two sides, one side is it is going to provide digital democracy, legal democracy to people. What are the pitfalls in the digital divide? I will come back to you on this question. So I just wanted to give you a little time to think about this question. And you can look at the Q&A because there are a few questions there. I will now come back to an AI expert. And I will now come back to Professor Pawan Goyal and request Pawan to talk about language. You know, in India, SUVAS has already been set up by the government of India. The Supreme Court has set up SUVAS, and many of our own language doyens are involved in machine translation. The second is about deep learning and its explainability, which is a tough question altogether. And Pushpak indicated about deep learning. So how much of it is applicable for India? How much of it is important for India? What can be rolled out? These are important issues in our minds. But I will ask Pawan to initially speak about whatever he feels is good. If he addresses these, it is good. Otherwise, we'll come back to this question later. Pawan, over to you.
Thank you, sir. Yeah, these are really interesting problems when it comes to solving AI problems related to legal domain in India. And my experience with the legal domain text analytics has been short. I have started collaborating with Professor Saptashi Ghosh from IIT Kharagpur, who is also an organizer. And that's where I got a few insights about this. So panelists before me have already talked about there's a huge potential and there is a need for applying AI in the field of legal domain because of a lot of pending cases. And what happens many times when we talk about AI for legal domain, people generally jump to case judgment prediction. But it's not only about judgment prediction. There are so many lower level things that are required, and many of them are like routine tasks that can be done by an AI system. And and that is what we should prioritize and think about, that how we can apply methods in machine learning and natural language processing to solve these tasks, and so that we can actually facilitate the lawyers, facilitate the judges, so that the pending cases can be reduced. So talking about language, for instance, so whenever a case comes, it comes from a common man, and a common man may not be conversant with language, with English language that is so prominent in the use of in the legal domain. So the common man would like to convey his ideas in his own language. And now, can an AI system bridge the gap between a common person telling about its own requirements, what kind of help that person needs, to maybe a lawyer who would possibly benefit from automatically getting the translation of this, extracting what are the important facts about this particular incident, what are the interesting facts. And once we know what are the facts, then, okay, what is the missing information? Like as a lawyer, I would go back and ask, so can AI system help in generating what are some of the clarifying questions, and that can be asked to the person. And again, this may not be completely automated, but can serve as a facilitator to the lawyers, and that can help them to improve their efficiency and build up further cases. And also it can help in giving very quick assessment and very quick input to the common people. And of course, there are so many other things at a higher level that Professor Pushpak Bhattacharyya talked about, that how do I find out similar cases, and how do I find out whether given a case, what kind of charges are applicable. So these are again problems where AI and NLP can be very handy. Now, when we talk about using AI and NLP, what kind of methods do we generally use? So typically, as you would be aware of, so now in NLP, so de facto, whenever we have to apply a method for solving an NLP task, even if it's a complex task, we generally switch to deep learning. And deep learning over the years has actually improved the state of the art reasonably well in NLP. And so given a problem, we always try to see, can a deep learning based approach be applied to solving this problem? Now, that is fine, but there are quite a bit of problems with that. Like initially, when the deep learning really started, this was more about getting more and more label data and using that to get better performance. But over the time, when we shift from general domains like news, etc., to domains that are very specific, like legal domain. So legal domain, you will not get that much annotated data that you will get in news domain. So how would you model? How would you tune your models that are trained on a large maybe the same problems like text entailment and information extraction problems are there in general domain. But how do I tune these models to work well on the legal domain, specifically in Indian scenario? How do I do that? So that is actually a problem that people have been working over the last few years. And how do I apply transfer learning? How do I apply domain adaptation methods that can work for low resource data, where you do not have sufficient labeled data? So deep learning is generally the method that is that people go to, but there is another concern that comes for deep learning. That is, they are not very opaque. It's not clear that how the system has arrived at a particular decision. This is not very clear, and that has given rise to the problem of explainability. So whenever I'm making a prediction, can I also explain the system reasoning? So what is the reasoning behind that? Now, when I talk about giving explainability, there are actually multiple aspects. For example, I can explain the model decision by just using the actual model weights. I can say, well, this was the input, this was its embedding, and these were all the weights on all the layers, and this is the softmax output. But that doesn't help in giving. That doesn't help because this kind of explanation is not interpretable. So we talk about explanations that are also interpretable. Now there are various methods over the years. For example, lot of researchers worked on using visualization-based methods. Like, can I find attention over different parts of the input and say, okay, these parts got more attention, and these are possibly there to explain. These are possibly responsible for the decision. Then there are methods that are based on, say, you can find out gradient change of the prediction with respect to various parts of the input.
Have we lost Pawan's voice?
Yes, and the video has also paused.
Ha, ha, ha. Ha.
I think there is network issue.
Right. So by the time Pawan comes back, I think we will again ask him to continue just to save. Let us wait 2 minutes. I think he's back.
He's back.
Pawan.
I'm really sorry.
Yeah.
Am I audible?
Yes, you're audible now. You're audible.
Hello,
You're audible, Pawan. Hello, Pawan. Pawan is having a network issue, it seems.
Yes. So meanwhile, can we take one or two questions? Maybe?
Yes. So let us move over to one question. Professor Ganguly, the first question that has been raised is, when can you say that AI sapiens are capable of being granted personhood? Then can you please elaborate on the difficulties that arise in granting AI sapiens legal personhood?
It's a very, very fundamental question, very good question. The first part is that we have to understand that in law, we generally define two types of persons. One is a natural person, the other is a legal person. Now, natural persons are, for example, the living humans who are there, and they are attributed that they have certain rights and duties. So they must, therefore, whenever we ascribe a personhood, that person must have certain rights, must have certain duties to perform. So that's something which is there inherent into the process. So that's the natural person. A legal person, like an institution, company, or any of these, are where the law recognizes that as a person, and then there the law gives it, ascribes certain powers and capacities, and those are essentially governed by people, by humans out there. So you have legal persons and you have natural persons. Now, coming to the AI system very briefly, that when you look at AI systems, The question is, can you consider that as a natural person? Possibly not, because that does not fall within the framework of it being the definition of a natural personhood, natural person. Now that leaves us with the aspect that can we consider this as a legal person? Can law recognize that as a legal person? In which case, we would recognize that as a legal person, then it must give it certain powers and certain capacities out there. And the question is that can it be then governed? Can it be run like a company is run by the board, an institution is run by certain people? Now, the question that comes in for AI systems, if they're completely autonomous, then the first question that comes, it can think for itself, it can do things for itself, and why does it need anyone to manage it? So, question that comes about is what are those contours of personhood arguments that we can put forth in favor of AI? There are today, as we look at, very interestingly, on one side, there are two, you may say, schools of thought. One says you cannot give personhood to AI systems. The other school of thought said, why not? Because if you take the Indian system, and that's why I'm now coming specifically to India. In India, for example, as soon as you go to, a murti is brought into a temple, and then you do the pran pratishtha. It's interesting, in India, that idol which has been given the pran pratishtha is actually under law considered to be a legal person. And then the priest and the trustees take care of that. And this particular idol is given the status of being a minor. Therefore, that minor is taken. So the arguments that go say, well, can we not consider AI systems along similar lines? Similarly, in India, traditionally, rivers like Ganga and Jamuna have been given personhood. So the argument that has come forth, if those have been given personhood, can we not give AI system personhood? So today, that's why I said we have to go very fundamentally into our constitution on number one, and then look at all the pros and cons into it. Today, the arguments, there are more arguments against than for, but we have been talking about this for quite some time. And that is the issue that we go about. Now, the question that comes in, that suppose the AI system becomes so independent of the human, the human loses complete control, then what happens? So there are many such questions that need to be answered before we can go and give a legal personhood to a AI system.
Thank you, Professor Ganguly. There are other questions Miraji has asked. We'll come back to a more open discussion on this topic and other topics. Pawan is back. Pawan, request you to continue.
Yes, sorry for the technical glitch. So yes, so I was talking about various methods in explainability, and yeah, so really why explainability is needed is that because it can help build in trust with the AI system. If it is seen that the method is explainable, it builds much more trust, and also it can assist in the decision making process. So yes, this is basically so there's a lot of challenge involved in both deep learning part and the explainability part. And of course, in the Indian scenario, we can possibly start by some short-term goals, like can we make systems that can help in automating the routine tasks? And then at the same time, we build a long-term research plan that how do we envision that these systems will become explainable, or do we, instead of working on methods that are not inherently interpretable, work on models that are inherently explainable. So that would be something that we would have.
Thank you,
So
Pawan. I think these are very important points, points specially related to explainability. And the other thing that you mentioned, which Uday also insisted upon, is how do the common people, you raised a very important point for India. How does the common people speaking common language explain their problem and difficulty? And how do we convert it to a legal framework and a legal statement? I think that itself, if we can do something about that for India in its multiple languages, I think would make a remarkable democratization, and I think it's an important thing. The second thing, other than explainability, so what does explainability entail for India? Explainability is known all over the world. People have studied, known its pitfalls. But what is the importance for India? Two other points which I would like you and Pushpak to come back upon are, one is data sets. You mentioned about data. So what should be our plan for creation of data sets? And how should we engage upon a research program? Because without a proper research program, we are not going to really start rolling out AI. Then AI will be rolled out by people who just make some software. I think we need to have a very careful assessment. So please think about this, both you, Pushpak, all the panelists. Finally, we come to the person who holds the whole hot cake with him, and Dr. Raghavender. He is the government of India for us today, and he represents the government. So he will tell us not only this side, he has another very important side. Other than AI and law, the whole of intellectual property is another very, very key area where AI is becoming more and more important in India. Litigations are coming up, new ways of, ensuring copyright, intellectual property, patent, and all that dimension which we have not yet discussed, but which is a very, very important thing because of its monetization, its economics, and its relationships. So I will leave it open to Dr. Raghavender. Thank you very much, and request you to share your initial thoughts.
Good evening, everyone. Thank you, Professor Partha, and all other distinguished panel members, Professor Ganguly, Professor Uday, Professor Bhattacharyya, Professor Pawan, and all other people on the panel. It is interesting talk. I congratulate especially Professor Partha and IIT Kharagpur taking this initiative to hold this a seminar, especially focusing on artificial intelligence and law. Many interesting topics have been raised by all the panelists. As you know, that the government of India, even though today I'm not officially representing government of India, but I'm a civil servant, so I should be careful with my words. But I talk about issues which are already in the public domain. Everybody knows about it. That first and foremost thing what government of India did was, it is from Niti Aayog. Niti Aayog came out with a artificial intelligence national strategy paper. So it gave an overall action plan guidance to various ministries and various sectors. Instead of working in silos, how this most cutting edge emerging technology, AI and data analysis has to be taken into consideration by policy making by various departments. You know that industry 4.0 revolution has come, and we already said that we should not miss that bus. And instead of machine to machine manufacturing, there is a manufacturing is taking place. So various important things are convergence happening here. Not only the main aspects of the artificial intelligence like machine learning, deep learning, whether it is descriptive or prescriptive or predictive analysis is going on, and neural networks, or using the natural language processing, as my other colleagues have said. Various aspects each and every ministry is working. Coming to the major issue, Professor Bhattacharya and Professor Uday has mentioned about the pendency in the courts, how AI can help. My friends, that the e-courts project, which was started long back, and now the e-courts phase 2 is working. During this COVID pandemic imposed lockdown, all the courts, right from the district courts to Supreme Court, during the lockdown period, were functioning because of video conferencing equipment was already set up during the e-courts project. So e-filing was already functioning. Last month, Supreme Court came out with the upgraded version of e-filing, that is e-filing 3.0. E-summons, most of the law commission said that 60% pendency happens because of delay in summons. So we are already using the technology. E-summons is happening. And recently we took up a project, consulting the Ministry of Corporate Affairs. We made them to use their database so that they automatically e-summons can be sent when companies are involved in commercial litigation. So entire data of mobile numbers, email ID made available at the time of e-filing their petitions. So that has been connected with the case information system software, the CIS software. CIS 3.2 is the major software being used and by courts under the e-court services project. Now, e-court services phase 3 is coming. Under the and Supreme Court e-committee, which manages entire e-courts project in coordination with the Department of Justice, they have already announced this project. They have shared the e-court phase 3 vision document. You can go to Supreme Court e-committee website, or you can go to Department of Justice website, download the phase 3 e-courts project vision document. You see that they are introducing how to use artificial intelligence technology, various data analytics, already available database in National Judicial Database. Professor Bhattacharyya showed a screenshot from that NJDG website about pendency of both civil and criminal cases, and what should be done, how these AI systems can be used, identifying the main reasons for the pendency. That is the main thing, so that a common guidelines can be issued to various district courts to reduce the pendency. This is going to be a disruptive step in reducing the pendency soon. And also mentioned about the another major area, that is the Motor Vehicle Act cases. Most of the Motor Vehicle Act cases are compoundable. So virtual courts have been started, beginning from Delhi to 7 high courts have started the virtual courts for their district courts. It have been functioning efficiently, and even filing of compoundable fee in case of traffic violations. Instead of going to the counter, you can use your mobile telephone and go to that virtual court and make the payment using any method of nowadays online payments are available. Today only I came to know that India has become the #1 country in using the online payments in the world digitally. That is the great thing happening. And another important issue was mentioned about how check bounce cases should be done. That is Negotiable Instrument Act. That is Section 138. And under that, Delhi High Court has taken initiative, started digital courts for Negotiable Instrument Act cases, especially Section 138. And during this COVID pandemic, it's really a disruptive development in Delhi. So a lot of things are happening using the technology. And then coming to AI technology, unlike use of other digital technology, you'll be facing a lot of interesting and new things, because regulation is going to be the most effective thing, most troublesome area, because use of AI is going to replace, if not replace, human decision making. it is going to assist the human decision making. That's what the most of the honorable judges keep saying, that we are open. Even Supreme Court said that, judges said that we are open to use of AI, but AI should not replace either judges or lawyers, but AI should be an assisting technology to make judiciary function efficiently or lawyers functioning efficiently. But the use of AI going to create new risks and also new unforeseeable circumstances in the law. How this has to be tackled under this law. I know many speakers spoke about amending the constitution or introduction of new laws, whether it is substantial laws or under the existing laws, new rules and regulations, etc. So general system of AI regulation is going to be attempted, and we have to see while attempting this regulation whether existing legal and regulatory schemes are going to take care of the new responsibilities and new liabilities and new risks which AI is going to create in the entire legal sector. And one most important thing in the use of AI to create lesser legal problem is transparency. Everyone is talking about the big data. So how this data is going to create new disruptive methods in various sectors, whether it is in the financial sector, whether it is in the e-commerce and trade sectors, and especially in marketing of various goods. Other day I was just Googling for a pet, tick reduction medicine for my pet on Google. Immediately I started getting advertisement on Facebook account about pet medicines. So it is going to be, and I know that it is an AI driven thing, and how AI system are functioning, and how this information has been collected, and wherever I am there, whichever platform are going there, suddenly this pet medicine, anti-tick medicine advertisements are coming. And online availability of these various platforms are being shown to me without I'm searching and without I'm asking for that. So this is going to be a disruption, but there should be a transparency because that during the COVID pandemic, in the phase 1 and phase 2, use of medicines has taken different turns. Initially, doctors were administering paracetamol and cetirizine. Then they jumped to hydroxychloroquine and other medicine, especially the antiviral medicine, which are used for other viral infections like HIV or Ebola and that. So most of them are Fabiflu tablets or remdesivir tablets and all that. Then I started a cocktail of these medicines and all that. Experimenting on humans, lot of data being created. All these are approved medicines, all these are patented medicines. But still, doctors do not know which medicine has to be applied for a patent, this infected patient of the COVID infection. So it went on, and then a lot of, apart from the vaccine introduction, which led to a lot of research data, and later once it is invented, the innovation came out and gave birth to a new vaccine, and then clinical trials gave a lot of data, whether it is phase 1 or phase 2 and phase 3. So all this data has to be made transparently. There is a lot of fiduciary relationship between data created and use. So there should be ex post facto transparency and ex ante transparency. So, and no data should be commercialized, and without the consent of the patients or without consent on the whom these medicines are used. And because it will lead to lot of fundamental right issues. You know that the famous Puttaswamy case is there and other cases there where Supreme Court has clearly said that the right to privacy is one of the fundamental rights under Article 21 of the Constitution, that is right to life and personal liberty. So it is very, very important that the laws should respect these things. And another important thing is AI and interface with intellectual property rights, which Professor Ganguly has spoke about. Person, whether AI machine is a person, because many people talk about that. AI, it is AI, a system which is inventing, which is innovating, which is expressing. I'm going to talk about whether AI can be recognized as a person. Can AI be a natural person, or it is only a legal person? If you declare AI as a natural person, then there is an AI-driven car invented by IIT Kharagpur. I'm sitting in that car. I don't need a driver. And then there is a technical glitch. And instead of taking me to IIT Kharagpur from Kolkata airport, it caused an accident and it killed a couple of people. So who is responsible for that? Who has a liability there? I'm sitting in the car. I should be held liable. Or IIT Kharagpur, which provided that car from picking me from airport to IIT Kharagpur campus, they're liable. Or the company, let us say some XYZ company which has invented this car, they are liable for this. Who are going to be liable? Then if AI itself declared a natural person, then how you are going to apply our IPC and CRPC and other provision? Can you punish a machine? And which section of IPC is going to cover that? So these are all problems coming into picture the moment you recognize it as a natural person. And then coming to intellectual property rights. In UK, one application was filed, UK Patent Office recently, and simultaneously under the Patent Cooperation Treaty, applications were filed in EU Patent Office and also US Patent Office. And it is recognizing AI as an inventor. The two scientists who developed this AI and AI went on inventing a product. So they wanted patent not for themselves, but the AI, because they said it is the AI which invented the patent. But thanks to UK Patent Office, EU Patent Office, including US Patent Office, they rejected, because at present laws are that natural person. Person means natural person will get patent, and legal person, for example, IIT Kharagpur, under whom various scientists are working, it can file a patent, but finally, who invented that, the person name has to be given. Again, some scientists who are working under the IIT Kharagpur umbrella research and development lab, that has to be mentioned. So this is the major issue. Again, coming to the copyright, again, questions people talk about, it is the expression. Whose original expression? Not the person who created the AI, but AI itself, because there are various neural networks and then advanced AI systems and algorithms like generated adversarial neural networks. This is most mind-boggling technology, algorithm technology. You simply feed 500 different varieties works of M.F. Hussain to this technology, AI technology, and then you give an instruction to this. You want a new M.F. Hussain kind of painting, and using and studying those existing paintings, 500 paintings, it will come out with a new painting. So it then then author of that painting going to be that general adversarial neural network system, but not the person who has created it. People will argue because it is out of its expression. Similarly, recently, Guardian newspaper in the UK, London, it come out with the op-ed editorial written by an AI machine in 500 words. It's a beautifully written editorial in 500 words, and it's the original one. It's not a copy-paste one. So how it has been created, how it has been expressed by AI, because a crazy idea was given to one intern, a law intern who was working in that newspaper, Guardian, and he fed a couple of documents concerning one topic. That AI machine read that and extracted the information, and then wrote a kind of text data mining happened there, and then it is written. So it's an original expression. So finally, you say that it's the original expression of the machine, copyright should be given to that. No, because recently a case made it clear that only a person can be given copyright, not a machine or animal. When David Slater left his camera on a tripod in Indonesian jungles, one monkey with the name Naruto is a macaque monkey and clicked a beautiful selfie. When David Slater tried to commercialize this, obviously the PETA has to oppose this, and the PETA lost the case in lower courts in the United States that Slater should not be owning the copyrights on those selfie photographs and commercializing it. It is the monkey which has taken the photo. With copyright law said the person who takes the photo is the author of that photograph. So, but argument here is monkey is not a person. So they lost the case. But when they filed the appeal before Supreme Court, there was out-of-court settlement where David Slater agreed to give 25% of proceedings, sale proceedings for the animal welfare activity, and the case closed. So still it is international law and various countries, it is the person. It is the person that is the natural person, is the creator, it is the innovator, whether it is the patentable subject matter, it is a copyrightable subject matter. So if you go to the patent, you're all innovator and scientists and engineers, professors teaching in IITs, your heart is very close to patenting and invention. So immediately you get a question whether AI subject per se is a patentable subject matter. So if you look at the TRIPS article 27, it says that patents, it talks about what is the patentable subject matter. So it clearly says that patents shall be granted to any field of technology, whether product or a process, which has novelty, inventive step, and industrial application. So computer softwares, algorithms, these are all give rise to AI system. So it is a patentable technology. And there is a case a famous case I often talk about, that is Ally's case, which Supreme Court judgment of United States. It's it's like a best of the best cases. All IP teachers discuss in their classrooms. So Ally's case is very, very important about the patentability of software, or a business method patent, including algorithms and AI-related computer-generated patents. So here question comes, whether all these algorithms, AI, software are an abstract idea. So court says these are all nothing but an ideas. These are all an abstract ideas. So these are not patentable subject matter. So similar question was posed before Delhi High Court recent, couple of months back. So what Supreme Court of United States said, okay, patent can be granted provided these technologies going to functionally make some device working. Yeah, they are going to assist the device to function, then a patent can be granted. So artificial intelligence is working. So then the patents can be granted to that. These algorithms can be patentable subject matter, or softwares can be patentable subject matter. So similar judgment was given, and clearing the doubts about the AI patenting in India by IP offices based on the guidelines they are issued for computer-generated works patenting. It is very, very important to know that India is one of the top 10 AI patent registering countries. So Indian Patent Office are doing excellent job in that, and this is happening. So question comes again, whether patentable subject matter should be recognized as a person, AI should be a person or not. So as Professor Ganguly mentioned about, there are a couple of schools. So there is a romantic school which talk about the patent should be given to only the natural person, or sometime extendable to legal person, but no machine, no animal can be granted. Whereas there is a revolutionary school which talks about granting patent to AI machine because they are inventing. I don't suppose this idea, because I go to the very basic theory of intellectual property, that is incentive theory. Whether it is the patent or a trademark or GI, design, or copyright, basically functions on the incentive theory. Why you give incentive? Why you fix a term of copyright, life of the author plus 60 years in India, or term of patent for 20 years? 20 years are common, because these 20 years, the inventor of that patent, the author of that copyright product gets an incentives. So he is incentivized in terms of royalties. So he will start getting those royalties, and then he will go and invent to more. So it is going to encourage him. So invent more and create more. So incentive theory, you can't apply this incentive theory to AI. So it can be applicable to only the humans. So that's how the entire IP system works. So there should be a new model. That's what Professor Ganguly talked about. That a model can be, the multi-stakeholder model. That is the modern approach, modern thought, which I forgot to mention. There is another school of thought is coming up, where they recognize IP ownership not only to the creator of that technology or author of that creative work, and the owner of that machine and machine itself, and also finally the user. So the technology must be created by a famous multinational company. IIT Kharagpur has brought it, and Prof.Partha is using and inventing something. So all these entities should be created, responsible for that creation, that innovation. So all these entities should have right over that creation. So this is what the modern school of thought is functioning. We don't know how it is going to shape, because it is still in the pipeline. I think that it has not reached it to at the final shape where we are using left and right. All this AI system is made us a robot. So robots are not functioning. We have become a robot because they are guiding us to live. So what to take, what to eat, what to do, what not to do. So that day will come not far away. Hopefully during our lifetime, we are going to see and enjoy that before you say goodbye. Thank you, Jai Hind. I'll get back. Yeah.
Thank you. You raised a very important, you provided information about our E-Code 2.0, 3.0, and the NJDG, the National Judicial Data Grid. I think these have been remarkable steps that have been taken, and I have been following it very closely as it proceeds. The Supreme Court has introduced two softwares, Suvas for translation and Supace for AI.
Yes.
So these are already on board. The other important thing that you talked about is the privacy and the bias issue. Both the bias and the privacy issue. I think these are also important things, and what they mean for India has to be addressed. Before I go to my questions, I think there are some audience questions, and since there are some very interesting questions from the audience, personhood, I will not talk about them now, but one question which comes both to Professor Bhattacharya's this one is, have you defined named entities for the legal domain? How many levels of NER may be required? Pushpak, would you like to take this?
Yeah, right. Surely an important question, but I think the question should be rephrased a bit. So, the named entities which are the named entity labels which are used in NLP, they are almost always from the MUC dataset, MUC. Okay, and there are three kinds of names: Enamex, Numex, and Timex. So numbers are also looked upon as named entities. Enamex is a very big class. It has artifacts, persons, organizations, all those names. And Timex is mainly date and time expressions. So this is fundamental to named entity labels and recognition. I think your question actually pertains to the ontology of legal terms. Okay, so this question is relevant. How many concepts should be organized in a hierarchical fashion in a legal domain ontology? So we have looked at that question in the context of information extraction in judicial domain, and what is relevant for your question is that we have tried to link the Enamex hierarchy, the MUC named entity hierarchy, with the legal domain ontology. Okay, so a particular case number is of a particular type, let's say, relates to such and such person, such and such organization. So link these named entities with domain ontology. And if you look at the experience of LIKF and this kind of ontologies, then you can see that they have about 8 to 9 levels in the conceptual hierarchy. And long back, there was this effort by Davis Lennart to create the CYC ontology. And these had 22 levels. And that was very ambitious. It wanted to capture all the concepts which we encounter in our life. So the answer to your question would be that the named entities will be from this MUC hierarchy. Fundamentally, that is the name hierarchy, but it should be linked to legal domain ontology, which has about 8 to 10 levels.
Thank you, Pushpak. Thanks a lot. There's a question for Uday from Meera Patel, and that question is, what are the safeguards? I'm just rephrasing the question. What are the safeguards you need to apply to while reducing pendency? What are the safeguards? You mentioned, I want to be more explicit, you mentioned about fines, or you mentioned about all these. As we move ahead, if AI makes a wrong decision, so how are we going to adjust that? How are we going to monitor that? How are we going to maintain the safeguard?
Yeah, so sir, what primarily I highlighted, as one of the priority areas for implementing AI or for bringing in AI is those aspects which are purely mechanical. And in that, the chances of having any kind of grievance to the litigating parties are minimal, because those are well set formats. For example, the submission of the document in the court also suggests that what shall be the margin area, when you submit the document. Then there is something called legal paper in which you submit. So those are well set standards. Now, if we look at those well set standards and try to get it implemented with the help of technology, then it will simply replicate that what has been happening with the help of human intervention. It is not going to set a new standard where you need to change the law, or where
the question that part is understood. That we know in the tax filing we have done. But what about the fines you mentioned, the quantum?
There, sir, now there are two ways of looking at it. One is where there are certain humanitarian factors which are taken into account by the court for determining the compensation. And other is a situation where there is a simple calculation which is to be done. Let's say, for example, I'll tell you, sir, Employees Compensation Act, which is a part of now labor code, where there is a formula given that if some injury takes place to an employee during the course of employment, then depending upon the age of the employee and the kind of injury, the compensation has to be determined. Now, this formula is already laid down in the law. Now, with regard to the humanitarian element, where the legal perspective plays a role, or where legal acumen plays a role, I think there where we are talking about implementation of AI, we are not talking about simply digitalization. So that AI which works on the systematic method is going to help, because AI is going to work on the basis of the data, and already the data is being created. Let's say, for example, if good number of cases with regard to Employees Compensation Act or under Motor Vehicles Act, where a pattern of compensation is already there, and with the help of that pattern, with the help of that data, if an algorithm has been developed, then obviously it will minimize any chance of biasness, and the safeguard aspect will be taken care of.
Yeah, so there are 2 points I want to continue on this thread, which is important. One is there is always an appeal, right? They can always appeal against a decision. So that appeal is there, and with digitalization we can speed up the appeal. I want to ask Pawan a question. Here he talked about using data. Now there can be bias, there can be anomalies. So do you see a scope for the data may produce something which is unique for a person? So is in the legal domain, this is a very interesting problem which has come up now. That is that while data says in general this should be done, suddenly somebody's case is absolutely unique. It does not match, but it requires a different consideration. So can AI really start detecting all these? Anomaly detection we know, but this part seems very interesting point.
Yeah, that's certainly interesting. So actually, yeah, so recently even in the works on explainability, so they are trying to see whether, so for example, one particular method for explainability was, how do I find out a similar example in my training data that can help me explain this case? Now, can such methods be directly used automatically to find out, okay, in this particular case, I'm finding this example, but this is not applicable. So what are the additional measures that can be brought in? It's an interesting problem. It's an interesting problem, and of course there are works. Recently, there are a lot of works on the data quality. But I think for the legal domain, this has to be looked from a very critical perspective. So,
right, I thought that this would interest you and Pushpak a lot as a problem statement, which is such that what are the new kinds of unique differences that occur, which is not managed by data, because that I think is a very interesting problem. Thanks. There's a question back to Raghavender ji. So here he says that, sir, you mentioned that incentive theory compels author or inventor to create. However, the IPR regime, in the IPR regime, incentive theory is balanced by social interest theory, which holds that AI generation is for the benefit of the society. So can it not be said that AI generated IPs be given recognition that it would promote social interest in a much better and more cheaper way? Raghavender ji, are you there? Professor,
yeah.
yes.
It's a very good question. Let us take a painter. Okay, he is very poor. He is very excellent artist. He does painting not only for his satisfaction, and his paintings are for the society. Everybody enjoy. Various themes, contemporary themes, he does painting, but basically support his family. The paintings which are sold to the art gallery, the money he exert livelihood. So let us say that it is for the social benefit. He will paint and read. How will he? Incentive theory for intellectual property came like this. So the same intellectual property law, even in the TRIPS, if you look at the general principles and objectives, Article 7 and 8, where it talks about technology transfer and intellectual properties and access to medicines. And it's all about the public interest issues, social interest you talk about. Issued balancing of rights. That's what the TRIPS talk about. This is one of the flexibility. And so various flexibilities have been introduced to take the social interest. And also there are exceptions and limitations in intellectual property law to take care of the social interest and public interest. The best one is exception for education, exception for the research. Nowadays, the main hot topic is the data issues you are talking about. The use of data is going to be multiplied with the introduction of large-scale introduction of AI. This data is going to rule the world. So how this data is going to be used? So when you do the text data mining, the Copyright Act, our Copyright Act, I'm talking about 1957 Indian Copyright Act, gives only general exception for non-commercial use of this data. So only for commercial use, you need to take, exception, the license. That's what the international practice, which EU also, EU directives in the single market economy for the digital copyright issues, they have done amendment and clarified in this regard that non-commercial acts like education and research, you are doing text data mining. No burden should be on the educational and research institutions. Even Delhi photocopy case has made it clear that copyright is not at a birthright given to anyone. There is a limitation on that. There is an exception on that. IP recognizes the social interest, public interest. It is ingrained in all international conventions, treaties, and our local legislations. The best thing in the patent law, if you see the compulsory license talk we are talking about during this pandemic vaccines, that government of India should invoke compulsory license under Section 84 and Section 92 emergency use and all that. So, but and without going into detail, whether these vaccines have been granted already patent or not. If a patent is pending, and because of that, still these vaccines are out in the market, how can you give a compulsory license? Because compulsory license has to be given to a patented product. But another thing, many medicines, what they have done, they have reduced the prices for the developing countries. And TRIPS flexibility is that member states can fix the prices for the medicines. So it can limit the prices. Even multinational drugs prices can be limited. So that's what India does. There is a national list of essential medicines concept in India. The policymaker, Department of Pharmaceutical, fixes prices for this. And the recently Remdesivir issue came, black marketing and non-availability of this medicine. Government came out with a list. So various, generic medicines are there, multinational products are there, Remdesivir versions. All versions, the list government gave. So if you take the Cadila, the Jadis Cadila, the cheaper rate they fixed, 680 rupees. So maximum multinational should be 3,500 rupees. This should not be more, because in market they were selling 50,000, 60,000. So like things, social thing is there, and including artificial intelligence. If you think why only artificial, there are so many technologies. Do you think the very event you are watching using your computer, laptop, and the mobile equipment, whichever mobile phone, it has come free for you? Has been provided freely in a social interest, public interest? No. You have paid for that. Even the internet you are paying monthly rental. So nothing is free, but the social aspect is there, and that is there. And government policy, the national document, national policy paper, strategy paper on AI issued by Niti Aayog talks about that. So incentivization is also there. Public interest and social interest is also. It is a balance in intellectual property. That's what I want.
Next question, I'll move to Professor Ganguly, who has hit such a topic that there are more questions than we can ask on that topic. The question is, can it be said that a viable solution to granting personhood to AI and it violates a human's right, and violating a human's right is to hold the algorithm designer responsible or suspend the use of that particular algorithm for certain users or for a certain duration? Is that a way of regulation? Is that a solution? Professor Ganguly, are you there or are you frozen? I think he is frozen.
Yeah, internet issues again, I think. Yeah, internet issues. So I could hear him, and also
let me move over to a question to Pushpak. To Pushpak, the question is that he says that in law, a legal section or a clause derives its meaning and interpretation from various sources, including parliamentary acts, judicial interpretation, national and international commentators, precedents. So in such a case, the human expert has to travel through various domains just to find out the exact meaning. Is it possible for AI to do the same?
Surely a very interesting question, and directly pertains to what natural language processing can do. So this is a question which requires information aggregation, information retrieval, information extraction, and then also doing a lot of text entailment, paraphrase detection, and so on. So we aim for such a situation. The current technology is surely not at that stage, but some minimal progress has been made. Surely, you can find out by creating what is called the document graphs. Okay, so if documents have common entities between them, then you create edges between nodes where the nodes represent a document. So we have been using it in our knowledge graph projects in many different situations. So I would say the answer to your question is this will be possible in not so distant future, but not very near to, by using these techniques of information retrieval, extraction, entailment, and entity relationship problems.
Thank you. Thank you. I think we'll wait for Professor Ganguly to come back. But before we are also in the end of time. So if there are any other questions, from the audience. Anybody would like to ask, please type in the question box, or you can even unmute yourself and speak. If there are any questions, please put them in the
No, sir,
box.
they cannot, they cannot unmute themselves. So if
Okay.
someone is interested to speak, please, raise your hand, like
Raise your
pressing
hand
the raise hand button, and
we
we
can
unmute you.
We can unmute you. So that would be a good way for us to manage what
Yes,
we
sure,
wish to do.
sure, sir.
As we come to a close, and while Professor Ganguly joins, I would like to request the panelists to give a 1-minute thing on the way forward. That means for India, what do you think is the first and only most important thing that we should do to integrate AI in the legal domain for India? Given the gamut of NJDG 3.0 technology available, data sets, research, all these, I would request one by one the panelists to come and tell us just one sentence about what you think is the most important priority. Uday?
Yeah, I will make a few quick comments as a parting remarks here. One is obviously when you look at the judgment making whole process, there also psychological aspect plays a role, and we have two well-known method of reasoning. One is intuition based, the other is belief based. So that's what really works even as on date in the real courtroom setup. And obviously AI can very effectively work when it comes to these two set of reasonings. Now, on the digital divide, the points are what you have raised. It is certainly a reality, but then I think this technological intervention can prove to be a, can be proved to be a boon because of the very fact that we already have a legal aid system in place, which is having a backing of the law under Legal Service Authority Act. So, and that legal aid schemes generally support the marginalized section and poor people. So, making that legal aid scheme more oriented towards this technology, investing more on that will certainly help those poor people. And also, I would say that this technology will also help in increasing the awareness amongst the client. So what we generally say as a kind of trapping syndrome, in this profession, that once you get a client, you somehow manage that your client is not running away from you. So this AI can really help in giving the right information to the client, that what are the chances of winning the case, and therefore the client can take a call accordingly. And then finally, sir, I would say that I see legal services in two parts. One is the public service of it, which is been happening through the court of law. Other is the private service, which is happening through the lawyer's office or the law firms. Let public service be, completely do the hand holding with this AI, so that access to justice can be available to everyone in an equitable manner, and at the same time, in a very effective manner. So that's what would be my concluding remarks.
Thank you. Thank you. May I request Pawan to make his concluding remarks?
Sure. So for me, I see that two main things that we should do on priority. One is that how do we make legal or any legal service accessible for common people, that they can, where they are able to convey their own ideas in their own language, and how AI can help bridging this gap. And second would be for law practitioners, how AI can help in fastening different processes by applying various methods for precedence analysis and charge detection and so on, while keeping, because for the practitioners, it is also important that the predictions also carry some trust. So there should be a bit more emphasis on how to make it interpretable, so possibly in the direction of how they relate to the actual law, and that interpretation can be provided. So these are the 2 points I would.
Thank you. Thank you. What would be your parting comments?
Yeah.
And suggestions?
Right. My wish list is that integrate machine translation very seriously into the legal process.
Thank you. Dr. Raghavender, what would be your parting comments?
Yeah, that is the right suggestion. That is the right suggestion by Professor Pushpak Bhattacharya. That Supreme Court has recently taken a decision on the translation issues and also the legal transcription. That is another area is very going to have impact on the pendency and time taken. So
I think we are losing him. So may I request Professor Ganguly?
and transcription, these are the most reasons.
Yes.
Depending
Okay. We cannot hear you, Dr. Raghavender.
using.
Yeah. So may I request Professor Ganguly to kindly not only talk about that topic which where the question on personhood came up, but also give his parting remarks, because we are now almost completed our time.
I think, what we need to do in India is look at first those regulatory issues that are well within our control, and then go to more fundamental issues. So therefore, the issues about data, protection, the data privacy and the security and all those other issues, which are fairly under control of the technology people, we look at those aspects first, and then look at some of the regulatory features, and then from there go to the more fundamental aspects like personhood, etc., in a longer term perspective. So that's the way I would really go about.
Thank you. Thank you very much. As we come to the end of this session, it is not because we don't have things to discuss, but because we have run out of time. The summary is very clear that India needs to move very fast on AI. The speed has been happening with the government. The researchers are also moving forward, and this seminar was a very important aspect. I don't want to give a detailed summary of this. What I have suggested is we will prepare a summary of this discussion and circulate. But before I hand it over to Kripa, I will also ask, myself being part of the organization team and the others who are here, I can see a lot of our organization team members are here. I would suggest that in order for us to create a roadmap, we need to get to all the stakeholders here who have participated in this seminar and collate the suggestions. Once we collate the suggestions, then we can put them up into priorities, and then we can create a document around which we need a massive scale operation. It cannot just be one seminar, two seminars for us to integrate this in a proper manner. And therefore, the academic community, the practicing community, the interface community, and the government and the judiciary, I think all of us need to work together. And I would request Kripa, before he concludes, and everybody else is there, Shaptarshi, Amin, Arnav, Ashutosh, Prashinjit, Upal, and Shubham, and everybody are there. I would request that we create a mechanism by which we can collate the suggestions from the larger audience. And once we get the suggestions, there have been also suggestions about, how we can assist advocates, etc., etc. So I think if we can collect those suggestions and create a document, and then continuously, progress and have a follow-up session, it would be great. With this, I would like to thank everybody and move over to Kripa.
So thank you, sir. Thank you very much for the wonderful coordination. I don't have much to say except thanking all the panelists to take some time out of their busy schedule to express their opinion on this very important topic. I would like to thank Professor Pushpak Bhattacharya, Professor Uday Shankar, Professor Pawan Goyal, Professor Prabuddha Ganguly, and Dr. Raghavender for this wonderful discussion. And I would like to thank the audience for being present with us throughout the session. And I hope that you have enjoyed each and every session. And thank you very much for the wonderful questions you have. This means that how much attention you are really paying to all the discussions, and how much homework you already have done to be able to ask such wonderful questions to the honorable panelists. So I will now hand over